Actually, my lord,
10 times. They have given compensation of
10 times compensation, my lord. When the such type of compensation, when the claim has to be filed within 6 months, my lord.
Yes, Mr.
On behalf of the
10
state.
times.
On behalf of the state, my lord.
See, the question of delay has been already examined by the High Court earlier.
Yes, my lord. And it has been remanded, my lord.
No. Not on that aspect.
To decide the matter on merit.
So far as condonation of delay.
Yes, my lord.
By the Assistant Labour Commissioner.
Yes.
Has been accepted.
Yes, my lord. That is.
So you can't be raising that issue now.
My lord, in this case, I have challenged the 3 orders. First, my lord, appellate court order, that is 9-5, it is against the award, my lord, in which about 83 lakhs has been settled to make the payment 80 lakhs is 50,000 something, my lord, to the employees of a cinema hall, my lord. And I have challenged all the orders of the labor enforcement officer, the appellate court order.
Award of the under the Minimum Wages Act.
Minimum Wages Act, my lord.
Yes.
Minimum Wages Act, without deciding the issue in question properly, with the limit of 8 years. The claim was made after 8 years, and that claim was taken up without properly condoning the delay. And my lord, the case was admitted without condoning the delay. When I raised the objection and all that, then the delay was condoned. 8 years delay was condoned without assigning any reason. And even on the merits, your lordship will find that simply the labor says, when I have paid the amount, I have paid the challan I have annexed here with, which I have paid for the provident fund etc. And then it was deducted from his labor, the amount which I have paid him as a wages, my lord. And he said I have not been paid.
Yes.
My lord. Award is in Excerpt 3, my lord. Award is in Excerpt 3 at page 37. And at page 38, the amount has been. That I'm placing everything, my lord. Actually, my lord.
10 times. They have given compensation of
10 times compensation, my lord. When the such type of compensation, when the claim has to be filed within 6 months, my lord.
Yes, Mr.
On behalf of
10
the state.
times.
On behalf of the state, my lord.
You are appearing for the
private response.
Yes.
Advance of the petition.
After the remand, my lord, that delay has been condoned. My lord, may kindly see page 26, my lord, the annexure 1.
Which is also being challenged, na?
Yes, my lord. After the order passed by this court, my lord, this is the order, my lord. At relevant portion is at page 31, my lord. I find that so far as the delay is concerned, my lord, I find that the lower court erred in admitting the case in so far as the condonation of delay was concerned. That was placed in the High Court order, my lord. Heard the matter, a fresh point has been raised, the appellant and condoned the delay, so and so. Now coming, my lord, to the other points, my lord. Every such application, there is a provision in the Act itself, my lord, that every such application for concerning law will be presented within 6 months from the date on which the minimum wages become payable, provided that any application may be admitted even after the period of 6 months when the applicant satisfies the authority that he has sufficient cause for not making the application within such period. Lord, that part also, my lord, has been satisfied, my lord. At the bottom of the, we find that the lower court's record shows that authority under the Act has condoned the delay in filing an application under the Act, and therefore there is nothing to show that the lower court acted arbitrarily or capriciously or in excess of jurisdiction. I think that order passed by the lower court is proper, and question of condoning delay stands settled. It is more than sufficient to clinch the issue in favor of the laborers. It is further admitted that once the minimum wages for any particular activity has been fixed by the prescribed authority in a prescribed manner, in the incumbent of all the employees to pay the minimum wages before the employees' laborers. In the instant case, I find that the employees of the cinema hall did not pay the minimum wages to their employees on the pretext that the financial condition of the cinema hall is in great condition. They cannot be allowed to flout the provisions of the Act, which has been enacted as a welfare legislation to prevent the exploitations of the poor laborers at the hands of the management to the seller. The applicant contended that they could not preserve the register as to the payment of the salary to the 9 employees is not tenable. Under section 18 of the Act, it is mandatory that every employer shall maintain such register and records, giving such particulars of the employees employed by him, the wages paid to them, and work performed by them, and receipt given by them in such form as may be prescribed. The proceeding was first filed back in 2002 and is now 2016. The intervening elapsed period of 14 years is an ample enough to pass or conscience to the say that award of compensation upon the 10 times of the due wages cannot be called arbitrary or malefic. The tendency of the laborers to fight their salary differentials so long as they should stand commended for the ends of justice. Had the management paid the prescribed salary and the laborers vested the same properly, it would have been faced them for more than compensation awarded to them. This is more so when the appellants fail to deposit even a single rupees to fight the case in the appellant court. In this respect, the compensation awarded cannot be said to be arbitrary. In view of the foregoing discussions and illustrations, the fact concerning the proceeding, I find that the contentions of the appellant stands negated and discredited. It is accordingly disallowed. The competent authority will consequently initiate measures to recover the outstanding dues as is prescribed under the Act or the rule as mandated under. This was the original order in 2002, my lord. Now we are in 2023, my lord. Orders after orders, my lord. On technical ground, my lord, this court remarks, my lord, that the delay part has not been properly considered, has not been contently discussed, or
nothing was discussed in the appellate order.
Then, my lord, that also was considered. That also was, my lord, elaborately discussed in the order itself. And then, my lord, this final order is passed, my lord. This is dated, my lord, 11/5/2018, my lord. 16, my lord, I'm sorry.
Where is the order of the High Court dated 17 July 2015?
Annexure कितना है?
Annexure 12.
Annexure 12, my lord.
At page 52.
16 का मांग रहे, 10 की तो 10 का। नहीं 17 का तो यही लास्ट ऑर्डर। हाँ। ओह अच्छा ठीक। 11/2/10 का।
See, the question of delay has been already examined by the High Court earlier.
Yes, my lord. And it has been remanded, my lord.
No. Not on that aspect.
To decide the matter on merit.
So far as condonation of delay
Yes, my lord.
by the Assistant Labour Commissioner
Yes.
has been accepted.
Yes, my lord. That is.
So you can't be raising that issue now.
Not I am raising that question. I am raising the question.
Regarding 10 times compensation.
10 times, and second thing, my lord,
All right.
on merit, even on merit, the court was required to see
That-
after 8 years,
The council, that question requires to be examined.
after 8 years, my lord.
Though the delay may have been condoned,
2002
but 10 times somehow.
2002 ऑर्डर।
Yes, it can be.
2002 का जो रुपया हुजूर आज के डेट में हुजूर पैसा हो गया है।
2 times करा देते हैं. If you agree, you will pass an order. 2 times.
इतना तो खर्चा हो गया। इस सारे प्रोसीडिंग में हुजूर हमको घसीटे वहां से लेके यहाँ तक हुजूर इन एवरी प्रोसीडिंग उतना तो हुजूर खर्च हो गया है।
No, not further, not more than that. You came after 8 years. That
8
delay.
years, my lord.
It is simply because they were giving assurance that no sooner
All
the
right, you are entitled for your wages. You might be entitled 1 time, 2 times, but not more than that. If you're ready, then we'll pass an order. If you're not, take exception.
आधा पर हुजूर कम से कम 50.
As observed by your lordship, that 2 times, if your lordship think it's proper, I may take the instruction on that.
Take the instruction. Otherwise, we will pass an order.
Call tomorrow also.
Next week.
Next week.
3rd, किस दिन रखते हैं? 5th को.
Fifth.
Fifth.